This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Adam Carolla.
Yeah, get it on. Got to get on. It's just we're going to get on. Welcome to Beyond a Reasonable Doubt, our little supplementary midweek fix for you Reasonable Doubt fans, because it's always breaking, and Mark Garrigus is committed to his listeners and the law. Are you?
And I'm committed to. By the way, yeah, I get to see you like 3 times a week now. And, you know, for those who don't understand the joy that brings me, I'm here to tell you I get a big smile on my face when I see Adam, and I get to take part in the crystal brain. So
I'll right back at you, brother. All right. So there's stuff going on in the Chauvin trial. There's Rudy Giuliani. What do you want to get started with?
Let's start with the Chauvin. Gary, do you have a picture, which was something that surfaced yesterday? One of the jurors, there you go. That's a juror, apparently, if you will believe what gets printed nowadays, that was supposedly posted prior to the trial. And the defense is going to make a lot of hay with this. They're going to argue that very similar. In fact, it reminded me almost exactly of what's going on right now in the Scott Peterson case, where there was a woman who got substituted in during deliberations and had not disclosed on her jury questionnaire that she had gotten a restraining order. Her excuse was she didn't know what a lawsuit meant. And so the California Supreme Court issued an order to show cause on the guilt phase in that case. Here, the allegation is that this juror did not disclose or didn't affirmatively or correctly answer the question about ever being at a BLM protest or a march for justice. And I think that's where this is going to come down to. There's going to be some question there. I did not have time today, Adam, but I thought that we talked about this particular juror during jury selection, and I have to go back and take a listen, or maybe Gary will. I thought that we were perplexed as to why they put this juror on in the first place. Do you have any memory of that with your photographic memory?
I would have to hear his profession, and I think his age is 30 maybe or somewhere in that. But if I heard the description of it as we were describing it, then it would probably jar my memory. Obviously, the photo's not doing anything for me because we didn't see photos of anybody.
Right.
Right. So
my first reaction was this. When I do jury selection, in fact, it's funny because in a trial pre-pandemic, the government did not want to have, and the judge wouldn't put on the questionnaire, what are your social media handles? And the reason is because almost every jury trial, I like to have my team search social media for the jurors. It's incredibly informative. You can, by just looking at somebody, when somebody takes a pot shot at you, for instance, on Twitter, if you go down and take a look at how many followers, who they like, what they retweet, and what they do, it takes you 45 seconds to figure out who that person is?
Right. Gary, You have what?
I can give you the blurb on the juror. It may be a slightly different one than we originally read, but this should jog your memory. Juror 52, a black man in his 30s who works in banking and coaches youth sports. When selected for the jury, he said he had seen the bystander video of Floyd's arrest and, quote, "I don't think Chauvin had any intention of harming anybody, but somebody did die," unquote. When pressed about assessing Chauvin's intent, the man said he could still, quote, "definitely look at the case from an objective point of view," end quote. He also said he believes discrimination exists well beyond what the news media reports.
Well, probably just that right there, well beyond what the media reports, because the media reports a lot of discrimination. So that seems like grounds for dismissal if you're the defense right there. But why didn't they find this earlier? You said yourself your people take a dive.
My people take a real dive, and I publicly, when they missed it, I publicly chastise them myself and everything else because, to me, it's job one now because if you don't take a look at social media of your prospective jurors and you miss stuff like this, it's a real problem. Now, if he, just like the juror I was describing, affirmatively answered something untruthful on the questionnaire, that is a significant issue. That's not something that you're going to be able to dismiss. And I don't know at a certain point whether this judge is inclined to throw it out or issue. I think he would not do it just by way of motion. What he would do, my guess is have a closed hearing, and during that closed hearing, have the juror get up there and be questioned. And having just gone through this with yet another case of mine, I will tell you that in that case, that was also a reversal. I can think of 2 reversals in the last 5 years on cases involving juror misconduct, specifically with questionnaires or extrajudicial conduct. That to me is significant.
Here is a conspiracy theory.
I love your conspiracy theories.
I know. I had my Giuliani one last week.
Right.
What if, because it seems very doable, this dive into everyone's social media. All you need is a smartphone and an assistant, right? So the fact that they missed this, his picture was around. I heard he'd done podcasts talking about it. I'd heard he may have done an interview with maybe the New York Times. So this stuff was out there on this juror. Would it make sense tactically to overlook that stuff, let him become a juror, and then use it if things didn't go the way you wanted it to go, which is sort of where we're at now?
If you did that and left a paper trail and it was discovered that you had done that, probably would not be as forceful, so to speak. But if, and I say if because I'm not making the accusation, if there was an affirmative misrepresentation on a questionnaire, and if you exhausted all of your peremptory challenges, some jurisdictions require that as well, then you've got a pretty solid case. And you can't put the onus, interestingly, because the defense doesn't have a duty to do anything. If the prosecution knew and didn't disclose, that could potentially be an issue as well. And by the way, they've got the best databases and ability to do a deep dive of anybody. The prosecution's got unlimited resources, and so they may have some splaining to do as well.
Is it possible that with all their resources and a very limited pool of people that they're having to research, it's not a kind of thing where it's like hordes of migrants are storming the border and we only have so many people to take care of the situation. This is a very small group of people, and you have a very large office with tons of computers. Is it possible that the prosecution didn't vet these people?
Well, I'm here in Miami at the National Trial Lawyers Conference. We were talking about this at the Criminal Defense Interactive seminar today. One of the things that you have to say is, if this was on his feed, then it would be mind-boggling. Yeah, this picture was on his feed. It's mind-boggling nobody found it. If it's on somebody else's, a relative, a friend's, or something else, that I can understand and would see it. If, in fact, there was a misrepresentation or something that did not trigger it, and it was followed up in questioning and wasn't disclosed, you got a whale of a problem, because all it takes is one juror to hang up a conviction. All it takes is one juror misconduct to throw a verdict in doubt. And this is a judge who is already agitated. He was agitated. They announced the $27 million settlement. He was agitated at the prosecution on the testing of carbon monoxide. And you and I talked about how agitated he got over Maxine Waters. Now you throw this in there, and you never know. I mean, you just never know. I don't want to overstate it. Most judges will do anything to protect the sanctity of the verdict. But at a certain point, there may be a cumulative effect. Plus, you also have this specter of the feds and all the reporting around the indictment federally and everything else. So maybe at a certain point, he says, there's something where the judge says, you know what, if the feds are going to indict him, so be it. I'm going to vacate this conviction due to the cumulative misconduct. I'll let the feds have their shot at it.
So if you're Chauvin's lawyer, what are you doing right now?
Well, I can give you a little breaking news that he sort of, since this podcast has started, he has filed a motion for a new trial based on prosecutorial and jury misconduct, specifically citing this as well as the judge's overruling or denying a change of venue request as well.
And do you demand access to the computers of the prosecution to see if they knew about this or not?
Yeah, I think you do. I think that's one of your discovery demands immediately. It's for the prosecution to turn over what they had in any social media search. And if they had that and didn't disclose this and let it go to a verdict, that would enhance the motion for new trial in this case.
Where did they find this picture, Gary? Do you know? You can check. And so predictions. What do you think happens?
I think that if the feds indict, it's a lot more likely that the judge either tables this thing, takes it under submission, or leans towards having some kind of a hearing. He's got to have some kind of a hearing, in my humble opinion, because he can't just let the record as it is right now sit. So an evidentiary hearing is going to answer a lot of questions, and then the prosecutorial compliance that will also give some flesh to this.
What about his behavior in the eyes of other jurors? So to me, if you interview other jurors and they say, no, he wasn't agitating for guilty, whatever, he wasn't that vocal about it, he sort of sat back and went along with the group, versus he was the tip of the spear for, indicting on all three counts. Does his behavior factor in, and can they ascertain that, and will they try?
No, well, most jurisdictions, and I hesitate because I'm not in the weeds in Minnesota, most jurisdictions, including federal, you cannot get into the deliberative thought process. All of that is off limits. You can talk about misconduct. You can talk about, would a juror have voted differently if they knew about a piece of newly discovered evidence, for instance. But the idea of getting into the deliberative process is kind of verboten, and most judges would exclude it and wouldn't let you go there. So that kind of stuff generally, unless Minnesota, like their spark of life doctrine, has got a completely outside the mainstream jurisprudence on this, I don't think you'd ever get there. But I will tell you what, Adam, by tomorrow, when we do the reasonable doubt, I will have an answer on Minnesota law.
Thank you. Gary, you're going to tell us about the image?
His uncle posted it to social media back in August in commemoration of the anniversary of Martin Luther King's I Have a Dream speech. So it was on his uncle's social media for an extended period of time.
Did he tag him?
It does not appear so, and that's why this hasn't come to light sooner.
Mm-hmm.
Yeah.
All right. So you want to talk some Giuliani?
Yeah, and then I'm going to let you go because I appreciate you moving here. So Giuliani, you left off with the conspiracy theory, and I've been wrestling with it because how much I enjoy your conspiracy theories. I still can't get over and for those who didn't hear Adam's theory, his theory was that he purposely kept the Hunter Biden computer there because it was kind of like a ticking time bomb or Trojan horse, so that if they came and they didn't take it, then you could make the statement that there was a political motivation here. Not to be lost in all this is that Alan Dershowitz, who's been on the show with us before, and Alan, who's been on many a high-profile case, has likened the Rudy Giuliani search warrant to a banana republic, if I'm not mistaken, recently. And a banana republic meaning that you're executing a search warrant on your political opponents once they're out of office. That was a complaint, by the way, for those who want to be dismissive of Dershowitz. That was a complaint that he was making about Republicans back in the 90s in Whitewater. And he was making the same argument then. People now, as Alan will tell you, he does not get invited to the same Martha's Vineyard summer
parties.
Barbecues and cocktail parties because he's got the same theory. And there is something to be said for the idea of a FARA violation, which Foreign Agent Registration Act, which are rarely prosecuted. And the last one, high-profile one that was prosecuted and went to jury trial was Greg Craig, who was prosecuted, by the way. He was a former Obama White House counsel who was prosecuted in Washington, D.C. and was acquitted, found not guilty by the Trump administration. So there is ox is getting gored on both sides. Be consistent, I guess, is what I would say. And I still am struggling with the same thing. If Rudy knew that this was going to happen, and clearly he had to know because it was being reported that twice Main Justice had rejected the search warrants, why didn't he go harder in on a pardon? I mean, if I could give you a laundry list of the people that Trump pardoned, why wouldn't he have pardoned Rudy if Rudy had asked for it?
Well, two things. One is recently, maybe the New York Times and maybe NBC, maybe a few other news outlets had to print retractions or corrections as far as Rudy being warned that the FBI had warned him that the Russians were surveilling him or looking at him. That was an anonymous source. We have to be careful about these anonymous sources because the FBI did not warn him that the Russians were, surveilling him, targeting him, which is kind of all part of the New World Order, and he's making a lot of hay on that one.
It was kind of you should flesh that out a bit because that's a crazy story. It was reported almost simultaneous or successive to the search warrants being executed that the FBI had warned him, and the implication being yet he still kind of plowed ahead, right? And they both had to be walked back. And it was not, this wasn't the Daily Wire, Daily Caller, Breitbart or something like that. This was mainstream media. And that's a pretty big fact to have missed, if you know what I mean, or to have run with.
Yeah, well, it's happening more and more frequently. I know we're crunched on time. The last thing that Giuliani said, because I heard him do an interview this morning, and I was curious about your thoughts on this. He keeps talking about his iCloud and how there was a warrant, and he said that warrant that they got to surveil what his texts were, what his information or where he was corresponding with Trump client. He said that happened the day he became Trump's lawyer. So when he announced he was going to defend Trump, then they got a warrant to say, we want to see what you're saying, essentially, with your phone and your computer to your client and whomever else. He claims that's unconstitutional and a violation of what have you. You tell me, Mark.
If it's true,
if it's
true that there was a warrant and there was no dirty team, taint team, special master, somebody to filter it, and they were invading the attorney-client privilege, the only way they could do that is if they were alleging that there's what's called a crime fraud. Otherwise, that would be unconstitutional. That would be an invasion of the attorney-client privilege, and unconstitutional meaning a violation of your Sixth Amendment right to counsel.
Well, the whole
thing is wild.
It's all wild.
Maybe we get Rudy on. Why don't we get Rudy on and ask him?
Well, he'll talk to anyone who'll listen. So
exactly.
We should see about getting him on because he has a lot to say, and he's eloquent, and you could be the judge of it, but he speaks with a lot of certitude. I will say that.
Absolutely right. If we can't get Rudy, we'll get his lawyer. We'll do one or the other.
All right.
Thank you for making the time today, Adam.
Thank
it's great to talk to you.
you, Mark. And until next time, this is Adam Carolla for Mark Garriga saying mahala.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.